So for our audience, could you define information governance and talk about the relationship between e-discovery and information governance?
So information governance is a kind of a new term. It's emerged in the last few years. It is a holistic way of looking at big data for multiple purposes. In corporations, in public sector institutions, we are all struggling with the volume of information that we are dealing with. It is important to have a conversation in the C-suite, in the corporate suite, to get a handle on the right policies and practices for corporations. We live in a post-Sony, post-Snowden world, and to that extent, every corporation and federal agencies as well, institutions of all types, have a set of issues to confront, to govern information from a perspective of access and e-discovery, litigation, from record-keeping statutes that are on the books where information needs to be preserved for oversight and auditing purposes, for privacy reasons and for security reasons, and increasingly for business intelligence and for doing analytics on data. And so the umbrella concept is information governance. E-discovery is a part of information governance. It's a very important part. Those of us who have been in the trenches on e-discovery for the last decade or two understand that we live in a digital world. We need to find stuff that's in the digital world, and we need to preserve it for purposes of litigation or investigations or whatever. And so the techniques, the tools that we have been thinking about and which have been evolving for the past decade or more, in my view, can be applied in other contexts in a broader realm of what I consider to be information governance. And that's exciting to me. I wake up every morning coming into Drinker Biddle thinking that lawyers can add value. We can have a conversation with our clients and with other lawyers at the firm where we're showing the power of analytics and using it in new contexts.
So I'm going to ask you to flesh that out a bit more. So here at Thomson Reuters, especially Thomson Reuters Legal, I mean, our customers tend to be lawyers, courts, judges, other practitioners aside. And so for attorneys who have worked and have some familiarity in the e-discovery field, what could they, more specifically, what could they bring to benefit information governance? For example, if they do have hands-on experience working with some of the e-discovery analytical tools, could you say a bit more about, what that skill set could bring to the table?
Sure. So let me though step back a moment and say that I come from a generation. I went to law school at the end of the 70s and graduated in 1980 from a law school in Boston, and I very much remember the West Publishing, going to the books, using Shepard's, the yellow and the red volumes. I am a creature of that. I mourn the day that wasn't the sort of the dominant paradigm of new lawyers coming up and only using online services, because it's a very tactile experience of looking for the West key numbers. So all of that. My skill set from there, Lexis, Westlaw, other services that we were exposed to, primarily Westlaw, were new ways of approaching research. So we have those skills, but we have been lulled into a false sense of confidence that we could type in some keywords, and in a discovery environment, in unstructured data involving email and other forms of communications, that a few keywords would be sufficient. And so there's a whole generation of lawyers of a certain age that thought around the turn of the century, around 2000, that keywords were golden, and that's the only thing that we would need to deal with. Then a whole bunch of thought and research went into looking at the limitations on keyword searching, and over time, coming up to now, where we're having a conversation in 2015, it's become obvious that there are very exciting prospects for doing a better job than simply relying on keywords alone. So we have in the space a set of analytical methods. and we could get more detailed. But there's a really interesting debate in the lawyer community and the bench and bar community is how much under the hood you need to know. Does a lawyer need to know about latent semantic indexing and how clustering works and how the line through the hyperdimensional space works? All of that is beyond the competence of most lawyers. It's like driving a car. Most of us don't really know how the car engine works, or we fly on planes and we trust the pilot. Judges are willing to trust lawyers who appear to know what they're doing, that are competent enough in these new techniques that have been blessed by the courts in the last 5 years or so, to hold forth and to say, hey, we have 1 billion objects in this case that we've produced a discovery. We've used these analytical methods, technology-assisted review, predictive coding, and we know something about it. It's a very interesting moment in the law where we're moving beyond keyword searching in the biggest cases to doing something new, which is to use the power of algorithms. And I admit that very few lawyers really know the mathematics like you do under the hood. But I'm not sure we have to. It's a little like a Turing test, little like what is the outcome? If we see that we have a richer population of documents that come out, more relevant documents and less non-relevant documents than we would otherwise get, then these methods are producing good results. And I think judges will increasingly be familiar with this, but it's a real interesting question about the competence of lawyers to put forth these methods in big cases.
Okay, interesting. So, but I'm hearing there's plenty of similarities, but there's also differences.
Oh, so I didn't, right. So in that long-winded answer, what I didn't do is make the leap to information governance. And here's the thing. The methods work if you're looking to have visibility into a large data set for whatever purpose. Let's assume that somebody comes to us at Drinker Biddle and says, we've got a potential whistleblower obligation, a whistleblower lawsuit that we're worried about. And we want to know, we want to have visibility into a data set. Has nothing to do with it at present litigation. It's not e-discovery. It's sort of prior to that, looking at sort of an early case assessment of the data to see what kind of issues are teased out. We can do that. People come to us, our clients come to us and say, hey, we got 1 million emails. We need you to come back to us in a week and look at it. Well, we can do that now. You couldn't do that 10 or 15 years ago. You can do it now. And the power of the techniques, it may not be the exact same task as deciding what's relevant and not relevant, but you are essentially categorizing information. You're looking for some amount of material that is potentially useful to you in whatever issue client is covering. So in a whistleblower case, it may well be that we can look to see a trail of emails that have the allegations or not, and that the company is concerned with. And we can do that across lots of different categories of law that traditionally you would never think to ask the questions and be able to handle a volume of information. But the analytics are so powerful that we can do that. So the information governance equation sort of comes from an e-discovery world. We know how to do it for litigation. There are lots of ways to use the power of the software in other contexts. And it's for the creativity of lawyers to figure it out. I'd like to think that I'm part of a practice that's pushing the envelope on doing that. But there's a lot of education in the legal community, not just at our law firm, but in every law firm and every lawyer across the U.S., at least in our context, in our environment, to make the business case of why to use these methods. That's something that is just happening now, and it's going to continue to happen for the rest of our careers.